Hi, everybody. Welcome to Trial Alchemy. I'm Monty McIntyre, your host. Glad to have you with us today. I've been a California civil trial lawyer since December of 1980 and a member of ABOTA proudly since 1995. I was a trial lawyer representing plaintiffs and defendants in a lot of different kinds of cases: business, employment, insurance, real property, and tort cases. For the last 15, 20 years, I've been acting as an ADR person, mediating cases, helping settle them, arbitrating cases, and acting as a referee deciding issues with ADR services. So I also host this podcast to help lawyers get great ideas and learn from trial experts like our guest today. And I also provide California case summaries that helps California lawyers with one paragraph summaries always easily know the new cases in their practice areas so they can win more cases. Now, today, I'm delighted to have as my guest Jennifer Doan, and she is the 2025 National President of ABOTA. She is a very experienced and very capable lawyer. She's a founding partner in the law firm of Haltom Doan, which is a trial and appellate firm in Texarkana, Texas and Arkansas. She represents small companies like Fortune 100 companies and individuals in high stakes games and matters throughout Texas and Arkansas. She concentrates her practice on complex litigation, which includes a lot of different areas: product liability, intellectual property, including patent litigation, antitrust, class action, personal injury, and of course, bet the company litigation. Now, she's won lots and lots of awards. We take all the time of the podcast to name them, so I'll name a couple of them today. She has been named as the best lawyers as the Lawyer of the Year in commercial litigation in the East Texas Tyler metro area. Now, Texas Super Lawyers has named her as one of the top 50 women lawyers in Texas and one of the top 100 lawyers in Texas. And she's got many, many other awards. She's been the lead trial counsel in a number of cases where she's defended companies in product matters in multi-district litigation, and she's obtained complete defense verdicts in patent infringement cases for companies like Hewlett-Packard, Amazon, and Yahoo in both Marshall, Texas, and Tyler, Texas. So without any further ado, Jennifer, welcome to Trial Alchemy. Delighted to have you here today.
Thank you, Monty. I'm honored to be here.
Well, let's start off with this. You've tried a lot of cases and you're very experienced in your trial practice. Tell us about one of your satisfying trial victories that you've had.
Almost all trial victories are, when you say satisfactory, they are all trial victories are satisfactory for sure. We're blessed to be able to have a great bevy of clients from the tech industry all over the world. And so from in America, from the Pacific Rim. So we consider ourselves very blessed. And with those, we've been able to make sure that we have a good group of cases that we can take on pro bono as well. So we've tried cases that involved a church split. And those are always really difficult, highly emotional cases. Or we've represented an individual who was locked into the locker room when she was a high school student and asked a bunch of questions about her sexual preference. And then we've also had cases where someone that was older was fired by the Texas Tech University out in Lubbock. And then we've had cases where a lady whose house burned to the ground up in Hot Springs, Arkansas, and her insurance company didn't pay, although she'd paid premiums for 10 years. So all those cases we've been able to take on a pro bono basis, and all of those are wonderful cases with great, great clients. Probably one of the most satisfactory cases that we've tried. A lot of them are, especially in the patent world, are really complicated. And so we're trying to figure out how to explain it to regular people like me and you,
Yeah.
Who are not patent lawyers. We tried a big case back in 2012 for Amazon lead for Amazon and Yahoo. Google was also in that case. Doug Loomish, fine trial lawyer from California, represented Google in that case. And the case was whether the World Wide Web, when it was invented, was it interactive or not? And while Amazon and Yahoo were both founded back in 1995, the University of California had the patent. I believe the patent was dated, it was either 93 or 94. So the technology went back really, really far before
Wow.
our companies were founded. So it took interviewing people from all over the world, including Sir Tim Berners-Lee, who actually wrote the code for the World Wide Web, and then trying to figure out the case we had ended up trying was only on whether the patents were valid or not. And that usually means is the patent any good? And obviously all patents are presumed valid when they are issued by the United States Patent Trademark Office. So you've got a really high burden. It's clear and convincing that you're having to overcome. And we knew that going into it. At the time we got that case, the largest patent verdict in the world was this case against Microsoft, and that case had proceeded to trial in Chicago, and this was before the Apple Samsung verdict. So we were trying our case in 2012 as to whether those patents were valid. Every time you accuse somebody of patent infringement, they get to have the defense as to whether the patent's valid or not.
Right.
And so it was making sure that made sense to regular people and having the right bevy of witnesses that came in to be able to tell their story and why that made sense. And you're talking about some really pivotal historical figures, and they're so smart that sometimes that it's, you don't know who you're ever going to have on the jury. So it was really making sure that they communicated really well. It was a really great case, very, very high odds. The result of that was that the patents were found to be invalid. It went on to the federal circuit, where all patent cases are appealed to in DC, and they found it's called a Rule 36 affirmance. They just affirmed the jury verdict without a formal opinion. The difference that made to you, to me, and to anybody that's listening to this is that the University of California didn't charge for the use of the web, which would have happened if for some reason they had the patent on the interactive web. The fascinating part, I thought, from our perspective, was getting to talk to all these really early web developers and learn their story. I tried to so many cases before this case, and I'd already tried two jury verdicts for Yahoo before that. Both were defense verdicts. We received other summary judgments for them already before, but it was trying to figure out how you tell the story, because you already had the trial that had happened in Chicago, where we knew there was a humongous verdict in favor of the plaintiff. The plaintiffs at the time were University of California, and it's a company called Eolus who had the license to the patent. And just trying to figure out which stories made sense, which stories were relevant, which stories weren't relevant, but were really good, and what the jury sort of wanted to hear. And so that was, historically, it was a great case to learn from, made all of our lawyers better. And so that was really exciting. We're against McCool Smith on that case. They're exceptional trial lawyers at McCool Smith. So it was a really fun case to try.
Well, it sounds like that was a fascinating experience. That'd be great.
It was. I mean, there's other cases that we've won since then, that we've gotten, like Litigator of the Week from, the Recorder out in California. But those aren't nearly as juicy to the everyday person like you and me. I mean, they deal with power over Ethernet. It's interesting, but it's not as interesting as how the web was developed.
Well, and you were trying to figure out which story to tell, because when you're the trial lawyer, it's like you're the CPA and the client's giving you this box with all this information. You got to figure out what's the important story that's persuasive, right? And
yes,
that's an important part of the art of being a good trial lawyer, isn't it?
it is. It's one of the most important parts. There was one of the, in that particular case, when the patent application was filed by the University of California, they had attached some computer code with it. And we found out that a man named Eric Bina was actually the author of that code, and he had not given permission to do that. And so, if you'll recall, Eric Bina and Mark Andreessen, they had founded the Mosaic browser with the University of Illinois. And it
Okay.
was the first browser that you didn't have to compile on your own. They left that invention there, and then they moved to California and they started Netscape Navigator.
Netscape. Yep.
Yeah. So
Remember
these
that.
guys are really, really smart. And the things they talk about are really over the heads, just in general conversation, are over the heads of most of regular people like you and me and almost anybody that's listening. And so I remember walking down the street in Chicago one night, and a group of us were going to dinner, and I'm with Eric Bina, and I'm trying to figure out how is he ever going to play in East Texas, and what is the jury going to think that they can relate to. And so we started this conversation where I was asking about different things, and he said, yeah, well, he confessed that he was red green colorblind. And I said, oh, that's interesting. A lot of percentage of different people are red green colorblind. He goes, yeah, that mattered to me because when we were designing how web searches were going to look like, we wanted them to be green, and then you click on it and then they're red, but I can't see that. So instead, we made them blue, and you click on it and they're purple. And I'm like, okay, this is something we can all relate to because everybody's done a web search before. And you now understand it's the reason why we pick blue and purple on the planet is because this guy is red, green, colorblind. And he was sitting down and getting to code the whole thing. So when he said, that's just not interesting, Jennifer. That's not interesting. It doesn't matter. We don't want to talk about that at trial. We want to talk about these lines of code. And so I'm like, no, no, no. They can't hear what you're saying until they know that you're normal. And
Yep.
so we have to tell a normal story first, and then they can listen to everything else because then they're interested. Is like, this is the guy that did that. So yeah, but just trying to figure out for every witness why they're important for this jury to hear from. And then in East Texas, we have timed trials. I'm not sure that you know that or
Oh,
not.
okay.
So every minute counts. It's like a chess clock that the court has. And so every
Wow.
minute counts. So you want to make sure your stories are good, relevant, and they capture the attention, and then you move on to the next thing.
Well, now, in addition to figuring out the stories and what you're going to share, how do you get these super smart people to communicate so the jury can understand them? What do you do to get them to be like a real person and simplify things?
Well, sometimes they are easy when you think they're going to be difficult. Like in that case, Sir Tim Berners-Lee, who wrote the language for the World Wide Web, the HTTP protocol. I went to visit with him at MIT with a group of other lawyers, all of whom were incredibly smart. Um, and but they weren't necessarily trial lawyers. So looking for the story wasn't what they were looking for. They were looking for whether we're right or not, which is equally as important. You do not
Right.
want to go into a case that you can't hold the verdict because you're not right. Um, and so I thought he might be a little bit difficult for a jury to understand. He was a great communicator from the
Hmm.
beginning, wonderful communicator. And so we hit it right off at the very beginning. And I will say that, when I was asking him about how do you already know how to bring this down for the regular person, he goes, it's all about communication. All of life is about communication. He says, so if you can't communicate, it doesn't really matter anything that you have to say. So he said, when I was out there trying to sell people to look at the HTTP language as
Yep.
opposed to another language, I thought my language was the best, and yet everybody's language is pretty good. And so there was another platform out there called Gopher that was owned by another university. And as soon as that university started charging to use the Gopher platform, Gopher, Gopher, he knew immediately we're going to win because we're not going to charge. Because he knew, and they had this vision that if we could all move things online, from banking to shopping to communicating with people all over the world, then everyone will be able to be better. Commerce will be better, research is better, communications better. So it's just this vision that they had, that they knew that it would all be better. And I got to tell you, from visiting with the heads of all these computer companies or the founders of the companies, they all had that same vision as well. Sometimes it was
Hmm.
imparted by a professor at university, whether it was undergrad or graduate student. And then sometimes it was just something they could see and know, oh, this is going to be really, really great. But it took years in building. And so they're very ecumenical at the beginning of sharing everything, because two brains work better than one, 10 brains work better than two. So they would share everything to make sure that it resounded. And then
Boy, that's
some
great.
witnesses, um, you have to get, how they could relate. And so I'm not, this is not my idea. I've definitely copied it from somebody else. But you'll ask, like, okay, that makes, I want to make sure I understand this story. How would you describe that very technical argument to your grandmother if she was asking, what do you do for a living? Or tell me about this project you just did, or tell me about why you did this and why it matters to others. And then they have to think for a second, and then they come back to how it works. So I have this, when we were trying this case a while back, we thought we had this case just locked in because all the visuals supported and all the documents that moved show that we were right on this case. And yet, for various reasons, the judge was not allowing demonstratives to be shown. I think
Oh,
he wanted,
no.
yeah, I know. So, and that was like our game plan. You show these demonstrative, we win. We've mocked everything. Both sides always mock everything. And so we learned during trial that wasn't going to happen. So I'm on the phone with my father that night, and he is this great trial lawyer as well. And he said, oh, okay, Jennifer, you're just going to have to get your witnesses to tell and paint the picture of how this works. And I
Yep.
said, oh, Dad, this isn't going to work because the judge is excluding all these demonstratives. And I don't know how we're going to be able to describe this to the jury in a way they can see it. And he goes, oh, Jennifer, you're so young. Before there was these demonstratives and before video and before TV, there was radio. And on the radio, we would listen around the radio and they would tell these stories and they would paint the picture of how this, and you could see everything. You
Yeah.
could hear everything. You could almost smell it. And you were sitting, right on the edge of your seat and anxious to hear what the rest of the story was. I thought, okay, that's fair. And then I said, well, I got to tell you, Dad, my witnesses are all engineers. So I don't know they can paint the picture. And he goes, you tell them they don't paint the picture, you're going to lose this case. I said, okay. So it just, the importance of how they describe what is going on was so, it's important in every case, but it's definitely important in cases where your demonstratives are very limited for a variety of reasons.
Well, Jennifer, I agree with your dad. I mean, back in early days when I was trying cases, you didn't have the fancy stuff you had now, but you got to
Yeah,
paint word pictures with your language, and that's very effective all the time. Even if you do have great demonstratives, it's still
exactly.
effective.
It is. So,
Yeah,
and research shows us that a jury doesn't want to just sit in their seat and look at a screen. I
right.
mean, they want a variety of ways to be able to communicate with. And so you might have
Yeah,
even just a flip chart, you may have some video, you may have
yeah.
some documents, for cases where the judge allows you to have a jury notebook to be able to underline in the jury notebook, what matters and why, whether it's a breach of contract case or a patent case or some other case that's heavily document intensive. But yeah, I
All
agree.
right. Well, let's go to you're getting ready for your trial,
Okay.
and everybody's usually preparing for trial in some ways from the very beginning. All good trial lawyers do that, but you've also got this final prep time. I don't know whether you have a month before or however long you have, but what's your process and how do you get ready when you know it's going to trial? It's time to get it all ready, time to be ready to stand up and say, we're ready to go, Your Honor.
Yeah, so we're a trial boutique. So a lot of times we're hired later in the case to try the
Mhm.
case as well. Um, and I assume when we're hired later in the case that case is probably going to go to trial. You always
Yeah,
have to assume your case is going to trial, even if it settles in the middle or the day before or whatever else.
yeah,
Um, usually about 2 months out. I think communication is the name of the game as a trial lawyer. So we would definitely want to communicate with our client. Here's where we see the opening statement being. So you, to be able to do that, you already have to know sort of who your witnesses are roughly going to be. And that can change from 60 days out to the night before. Because, you
Yep.
get rulings on motions in limine. You have sometimes experts or other witnesses that have issues coming up. But I don't think you can ever prepare too much for a case. You can definitely overtry a case. That's a different issue. But as far as, yeah, that's different. You can call the one too many witnesses. You can ask the one too many questions, et cetera. But as far as being prepared, knowing what all the witnesses are going to say so that you can decide, all right, this has come in through this witness. This has come in, so I don't need to call this witness now. So just because they're on your list doesn't mean that you have to call them unless your jurisdiction requires that or something like that. And then you can always ask the judge. But we usually have, it's about 2 months out is usually our sort of our timeline on making sure everything is ready, locked and loaded. Everything is supplemented. You're looking at having a draft opening statement for the client so they can see where it's going. We usually have a sort of a walkthrough with the client so they can see this is who's going to testify about what. Here's the strengths and weaknesses of this witness. If your case is a slam dunk, you should win that case, right? And if your case is absolutely terrible, you're looking for a way to try to resolve that case from whenever you learn the case is absolutely terrible. But usually cases are in the middle. So there's good and bad about everything. So to assume like, this is my golden witness and they'll never speak anything wrong, you might not know your case as well as the other side does, So
I don't know if any case ever is a slam dunk. I mean, there's always risk on both sides.
Yeah, there was one case we had in Pennsylvania. We thought we should win, but there were, warts on both sides. And then we mocked that case. I think we mocked it with 6 different panels. We won every single panel. And that alarms me as when I'm trying defense cases, because that usually means you don't have the right person playing the plaintiff, or you don't have the evidence that the plaintiff thinks is about to come in. And so, but then we got summary judgment the next week. So, those things.
Well, that's good.
Do happen, but yeah, so probably about 2 months out is our sort of time frame on all that. So,
So you're doing your final prep about 2 months out. Great. Well, let me ask you this. You've tried a lot of different kinds of cases and a lot of different kinds of jury settings. But in terms of themes that you've used in your trials, and you're often on the defense, what are some effective themes that you've used that you thought have worked pretty well for you? And I'm sure it's going to be case specific, but what are some examples?
It is. So, there are certain lawyers that use the same theme every single time. Those are really fun lawyers to try cases against because you just get their transcript from their prior cases, all of which is public in today's world, and you can figure out where they go. So you really don't want to do that. I guess I'm trying to think of how I was probably a 10-year lawyer before I read Jim Perdue's book on who will speak for the victim. It's obviously written for plaintiff lawyers, but it is an absolutely fantastic book of how to tell the story and making sure the jury gets the story. So if the plaintiffs are reading those books, what I was taught from my first litigation boutique in Dallas is you want to know everything the plaintiff's lawyers are doing. So I read Who Will Speak for the Victim, Rules for the Road, Jim Ball's book on damage it was on damages. There's reptile books, etc. Rules for the Road is a great book as well. It's on knowing what the rules are for your particular industry and then sort of saying how they broke the rules, etc. So trying to think, I think it was the second or third patent case we were trying. And I had this idea, we were going to have that for a theme. Of course, everybody on the team thought I was crazy. And I said, no, I really think that it's important that this invention was put out in the public by this plaintiff more than a year before. And so It was like, so the rules in patent law is that if the invention's already been given to the public more than 365 days, and it's a bright line rule, then that patent is dedicated to the public and it can't be patented by anybody.
Ah,
Okay.
okay.
So you want to know who your rule followers are, and not, and you're bleeding hearts and you're picking a jury, because if they're going to, it's a bright line rule on what this is. But someone
Yeah.
may say, oh man, you're talking about 368 days. It's 3 days. Maybe they miscounted. Do you count weekends? So you want to know who your rule followers are. And then you want to show them that they knew what the rule was, and they still delayed, so that they get to see. So it's like the rules of the road. This was the rule, and they did not follow the patent rules. So they don't deserve the patent protection that the federal government gives inventors. So,
And
and that worked
how,
out really, really well for us. So we
well,
wanted to
there
complete.
you go.
Yeah.
Yeah. So you basically took kind of a theme that the plaintiffs often use, and you used it in your case, and it worked great.
Yeah, I had never, till today's date, I don't think I've ever seen, I'm not saying it's never been done, but I've never seen a plaintiff use sort of the personal injury plaintiff themes. I don't
Yeah.
see those very often in patent cases. So to the
Right.
extent you can use anything like that, and I tried so many personal injury cases, product liability cases,
Yep.
civil rights cases. So by the time you're doing patent work, you just need to be a great storyteller and know what resonates with juries.
Yeah. And I think one of the things about that's fun about being a trial lawyer is you want to be strategic. Every case is different.
Mhm.
And the fact that nobody's used that theme before doesn't mean it won't be a great theme for the case.
Yeah, and it could be a great theme for the case, talking about doing your opening statement early, and
Yeah.
you're clearing this with a client, and you've mocked it, and then all of a sudden you get to motions in limine, and the judge says, you can't tell this jury that this patent is about email, because I mean, I can't remember exactly how many times, 900 something times email was used, because it was designed to be a patent on email. But
Ah,
that wasn't the claim that we were being sued on. And so the judge says, you can't tell this jury that. I'm going to prevent you from saying that's an email patent. And
wow.
obviously that theme had resonated really well with us. And so, and of course, the other side, who is as smart as you are, or smarter, is
Yeah.
always mocking the exact same case from the
Yeah.
reverse. And they saw the same thing, right? So they had moved on that. We lost on that. And so our theme became to read the patent. And we wanted them to read the patent. And we we're telling, grocery store owners and regular people, teachers and construction workers, to read this patent, and they would rather stick pins in their eyes and read the patent. So how do you get them to read it and why it's so important? And then tell them, how patent cases are tried to juries, to regular people, because that's the way the United States system is set up. And we know they could read this patent, they could see what it's about, and we don't do that. So, yeah.
Yeah. Interesting.
Yeah.
Well, now we've talked about themes. Let's talk about, as you're getting ready to start your trial, what do you think is the most important part of a jury trial, and why?
So I think the most important part of the jury trial is voir dire. And let me just tell you why. And I know for anybody, I guess, especially if you're in California, we butcher the term voir dire. That's how we say it in Texas. If you say it differently, you don't need to be here. So, but that would be voir dire somewhere else, right? So,
Yeah. It's said
I
differently throughout the country.
yeah, so I still think that is the most important part of the trial. I thought that when I was trying suits on notes, when I was trying product liability and safety
Yeah.
belt cases. I mean, I was trying all kinds of cases that I've always thought voir dire is most important. You cannot prepare for your voir dire the night before. I mean, you can, but it's not going to be nearly as good as it should be.
Right.
I think you should really think, when you're picking a jury, what does the jury think when you're talking to them? And so, for example,
Right.
when they're drawing a patent case, do they think, oh, goody, I get to have a patent case? Or are they thinking, I cannot believe I did not get a case dealing with murder or wrongful death or something like that? And of course, that's what they're thinking. Almost always, it's like, I'm not the right person for this. I've never done patent work. So you
Yeah.
have to have that mindset when you're preparing your voir dire every single time. And then as much as you think that your client's the greatest and you don't want to embarrass your client, and you don't want to ever embarrass your client, but part of being a great communicator is telling your client, this evidence is coming in and it's not good for us. And so we
Right.
want to be the one to broach that. Now, when can you broach that? You can broach it from voir dire on, as long as it's okay with the judge. So
Right.
one of the cases we tried, I believe it was last year, it might have been the year before. Both sides had some emails with bad language, you know,
Right.
and we were in East Texas, and some of our jurors aren't going to appreciate that. And probably between both sides, ours were the emails that the bad language was going to come in. And so you need to know that. And so I had to broach it with the client to say, I want to address this. I want to make sure it's okay with you, because here's the deal. If a juror says, I'm going to hold that against you, we need to know who that person is or persons and have them off the jury. And if we wait until that evidence comes in, you're never going to know. You think you're persuasive, but you're really never going to know if
Right.
it's somebody thinking, oh, well, if you're going to use that language, I can't listen to anything else you have to say. So it's just getting that issue out of the way. But I think preparing for voir dire really, really early, consider whether your judge will allow graphics in voir dire.
Yep.
Consider if the judge won't allow graphics, like I'm talking about, slides during voir dire. Does the judge allow pictures during voir dire? If the judge allow any of your exhibits during voir dire, and some judges do, and some judges absolutely do not. So how are you going to portray those same themes? There's one case, it's a long time ago, when both my daughters were younger. I was trying to figure out how to communicate this thought to a jury. It was one of the first patent cases we'd tried all the way to verdict. My kids were little, so we dealt with, those, you're doing a jigsaw puzzle and they have huge pieces.
Yep.
So I made a jigsaw puzzle of Mount Rushmore, and I made it in 6 pieces. So they're real big pieces, because there were 6 claims. There were 6 elements to this particular claim. We had one claim and 6 elements, which means the plaintiff has to prove each element by preponderance of the evidence in order for us to have to have a defense. Of course, we'd have a defense anyway, but in order to prevail, they have to have the evidence on that.
Right.
So I had those 6 puzzle pieces up there, and we did 5 of the 6. So that's the other kicker, is it's not going to be like I'm going to be able to tell you that, hey, they have to prove each one of these. It's like, it took one piece away to show we're going to admit we do this part of the puzzle. And I'd taken, I think, George Washington's head off. And so, you knew who it was and the shape of the piece because all the other 5 pieces are up there. But it's putting the plaintiff to the task of proving this element. And don't assume just because we're a computer company and we do
Yeah.
these other 5 things that we do the 6th one. And then I told them, of course, we are going to tell them how we do it differently, but I want to make sure that they see where the nub of the issue is right from the get-go. And that, from polling the jury afterwards, that was a thing that helped them. They thought they understood. That was why this element was so important for us to understand, and whether you did that or not. And the whole focus of their framing of the case was, but do they do this or not? They might do all this other stuff, but she already told us that from the very beginning. So do
Yep.
they do this or not? And so that was really obviously one that was very helpful.
That was very important, voir dire. Let's go back to your bad language thing.
Yeah.
So let's say, I want you to kind of explain how you dealt with that in voir dire. And I'm also assuming, but tell us, I imagine you're bringing this issue up and you're also wanting to explore if you can get any challenges for cause, if you need to get people removed. But how did you deal with this bad language? What did you do in that particular voir dire?
So I explained that the judge had already pre-marked all the exhibits. So we knew exhibits were going to come in, that we were both big companies, because we were both sides, plaintiff and defendant. And sometimes with companies with thousands of employees, sometimes employees, use language that we might not use in everyday language. And you might
Right.
see some of that language, and some people call it bad language, some people call it blue language. It's depending on what you call it. But there was going to be language in there with curse words. And while hindsight being 2020, we would wish that those did not exist. We wanted them to know those documents. They may see those documents, very likely would see those documents. Now, we were a huge company. The other side's a big company, but they're not anywhere close to how large we are.
Mm.
And so I just said, I understand where we are. This is the question I have. If those language comes in and it's against my client, that it's one of our documents, and it's okay. Listen, whatever the answer is, there's no right or wrong answer. Are you going to sit there and think, I cannot believe somebody that works at this client uses that kind of language? And is it going to affect how you feel about it? And there's no right or wrong answer. And a woman raised her hands as she was outside the strike zone. And she came forward and she just said, it would. I teach Bible school class, and this is something that's fundamental to me. And I don't want to see that language. And you can tell me it's going to come in against both clients, but I'm telling you, you're larger, your people should know better. And to that, I said, that is so, you think that would make a difference in you being able to be fair in this case? And she says, it would. I said, I so appreciate that honest answer. And that's what I'm looking for. And then you do the looping technique where you see, is there anybody else out there that feels the way Miss Smith does? Because you want everybody that feels like Miss Smith does to tell you right then, especially if they're in the strike zone. Because if you strike somebody for cause outside the strike zone, it doesn't matter.
Yeah, and if you get them to admit that, I don't know about it in Texas, but I imagine it happens. Certainly in California, a lot of times your trial judges will try to rehabilitate the witness or
Yeah.
the juror if they think, well, I don't think I could be fair. Do you do anything to kind of cement that in and say, hey, this person has really indicated they can't be fair in this case?
Yeah. I mean, I think you get them to say they can't be fair. There's no way that you're going to be able to prevail from the get-go, that kind of stuff. But I will say that no matter what you get, the judge, if the judge wants to try to rehabilitate, is going to do that. And if you are the plaintiff and you're picking the jury, the judge, I've never seen yet the judge say, I'm not going to allow the defendant to try to rehabilitate. And I guess there could be a circumstance where they find out they're related to somebody, but usually what happens there is the judge takes care of that a different way. Either they get to leave automatically or they just sit there or whatever. We had a case last year that someone else tried. We had the companion case, same plaintiff sued two different defendants, broke it up into two trials. And on the first trial, it was my paralegal's wife was on the veneer panel. And so the judge just asked that she not respond to any more questions. And she didn't. And so because it came pretty clear that she knew about this case, and she knew about it because her husband was working for our firm. Yeah. So you don't want her to leave then, because there's no telling what someone else is going to say to try to get off jury duty. But even though they, depending on your jurisdiction, might be able to be rehabilitated, here's my thought. Man, once somebody tells you they're not going to be fair to you, they're not going to be fair to you. They're being honest with you. And so if the judge gets them to say, well, maybe I could be, I'll try to be, yes, I'll follow the law that you give me, etc., they're not going to be fair to you. They've told you they weren't going to be fair to you. That's just, I mean, I think when someone's honest about that and they're trying to give you their honest, forthright answers, once they say that, so maybe you use a peremptory on them, but you don't need that person on your jury.
No, I think you have to use a peremptory on them.
Yeah.
And my concern is I think too often the trial judges, even when somebody is very clear that they're not going to be able to be fair, they really bend over to try to rehabilitate them. But I don't think that's what you want for anybody.
No. And there's times just as a human nature. So a case we were trying in California, there's great benefits to trying cases in Texas and Arkansas for Yahoo because, they provide a lot of things for free. We're sort of the flyover state, so we don't get to see all the minutia of everything that they do. So we're up in Oakland, California, and we're trying a case. And David Philo, who is one of the founders of Yahoo, is one of our company, Face the Company witnesses. And we happen to have in the strike zone on our veneer panel someone he's fired while we worked at Yahoo that David himself had fired, not
Oh
that
my
was fired.
goodness.
Oh, yeah, exactly. And so naturally, that guy is like, he did fire me, but I can be fair. I've put that aside, you know. And I remember visiting with our consultants and thinking, I've never been fired, but if I was fired, I would take that to my grave, you know. And I think that's how regular people are. And
Yeah.
so, as much as he could say he could be fair, we couldn't get him off for cause. I mean, he knew that was coming in, you know,
Yeah.
and so we let him go. So yeah, but there's times, Monty, as you know, that you only have a certain limited number of peremptory strikes,
Yep.
and you have more people that you think you want to strike, you know.
Right.
So there's different ways you can try to to deal with that. One of them is, and most judges that I've been in front of do simultaneous strikes where you pick three or four and the other side picks three or four, and then they all come into the judge and he or she marks their jury their sheet. Okay, well, sometimes during those you get common strikes, and so if there's more, or in both sides, sometimes it happens on both sides, so we agree, you can have the plaintiff pick somebody, then the defendant strikes somebody, then the plaintiff strikes somebody, the defendant strikes somebody, so
Yeah.
that you're both getting the maximum bang for the buck as you
Yeah.
go. Mm.
Yeah. I think the successive strike is what I've seen most commonly here
Yeah.
in San Diego and California. Well, now in Texas, in these trials, patent and other trials, do the courts allow you to give many openings?
So here in East Texas, they allow about, before we pick a jury on voir dire, about 3 minutes to tell you about the case, not argumentative, but just
Right.
what this case is about. So,
Yeah.
you know, we represent so and so, this is who they are. They've sued us on this patent or three patents or six patents or how many other patents are. So you understand what that is. These patents are about X. Hopefully, you describe it in a way that's understandable to most people. You're going to be able to hear arguments about this, you know, so they can see you've got witnesses coming in from both sides. Our defenses are either we didn't do it, so we don't infringe, the patent's invalid, um, some other defense that you may have. There's
Do
several. Yeah.
you do you use the mini opening in addition to the voir dire as a place that you can introduce some facts that may be hard for you or bad facts for you?
So it depends on how much the judge is going to let you go into the facts of the case. There are
Hmm.
certain judges that say during voir dire, you're not to talk about this case. And on your mini opening, you can talk about very high level only. And so getting to exhibits might be perceived to be a little bit granular. My advice on that is if there is any question about anything that you have, raise it with the judge. It doesn't have to be at pretrial 2 weeks before because you might not have thought about that. But most judges
Right.
have pretrial either the day before or the morning of
Right.
when you're working out last minute details. And just
Right.
tell the judge, we're thinking about asking, you know, kind of covering this. Is this too much detail, Your Honor? And most judges want you to they know that you know the case, both sides know the case probably better than the court. And so they want you to be able to try your case. So they may ask, what, tell me why that's relevant. You know, are you still going to stay within the 3 minute time limit? You know, yes, you can use that, or no, you can't. And that way you just know before you stand up, because you don't want to speak something that is ever going to, the judge may not call you down, but his or her impression of you is colored because they think that you've done something that they didn't allow. You don't ever want to
Yep.
have that.
Right.
You're
You don't want
you're
that.
just the mouthpiece for your client. You really want to stay way above any of that.
No, you're an officer of the court,
Yes,
and you want to be somebody that the judge feels they're following, you're following whatever their rules are that they're setting for that trial.
absolutely. No
Yeah.
surprises. You know, you can
Yeah.
tell I'm in federal court more often than state court. State court may allow surprises a whole lot more often, but federal court judges, they usually want to know what's about to come in.
Oh
So,
yeah. No,
yeah.
they definitely do. Now, in terms of your voir dire, and that's the key part of the trial, in your view, when you get to the point where you're giving your opening statement, what's your strategy there, and what are you trying to accomplish, and how do you tell your story?
Well, sometimes when you're talking, when you're gonna have your, because you have to have your opening prepared, ready to deliver right after the jury is selected.
Oh yeah.
We've actually had cases where we did not think we were selecting the jury opening statements until the next morning, but we ended up having the jury in the box all ready to go before lunch.
Yep.
And the judge just said, let's go ahead and start with opening statements so we can be maximum use of our time. So everything has to be ready in advance. And then you just figure out, am I going to incorporate anything from voir dire and putting in your opening? In voir dire, you're having a conversation or a
Right.
visit with the jury.
Right.
And if you envision it like a conversation or a visit, as opposed to, I'm asking you a series of questions and they're always the same series for every single case. And you say things like, I take it by your silence, you don't have any opinion on that. That is so cut and dry. You really want to have a conversation that
Right.
involves everybody, right? And so when
You
you
want
want
to
to,
engage them in the conversation.
yes,
Right.
always. And plaintiff should and defendant should, because it
Yep.
doesn't matter who's asking the questions, both sides learn.
Yep.
So what of that did you learn either from the plaintiff's or the other side, whether if you are the plaintiff or the defense side, that you want to recall them back to during opening? And we've done that before. We've also done so in the patent cases, they have patent videos. I haven't done this in a long time, but for a while there, when our case relied really strongly on the fact that we probably might have done what the patent required, but we were saying the patent wasn't any good and the patent was invalid. So there's a patent video that's put together by the Federal Judicial Center. And so we would use clips from that or lines from that show it's got to be verbatim. This is what Judge Davis or Judge whoever Smith just showed you before the trial started, and
Right.
recall this is the reason why you can bring this claim. And then you could go through what those are, and then you could say, we have these two reasons, so let's focus on those. And then you start talking to them. But they're more about talking to the jury then, and then you can't talk to them again until the end.
Right.
So, yeah.
Right.
Mhm.
Okay. Well, now when you get in your presentation of your evidence, you're going to be dealing with both direct exam and cross exam. In terms of the presentation, I think everybody thinks of cross exam as important, but direct's pretty important too, isn't it? You've got to tell your story and make it interesting. So what do you try to do in your direct so you're getting to the point, telling the story, keeping the jury interested?
I think direct can be part of the hardest part of the case. Cross examination is fun.
Yeah.
You own
Right.
this witness, it is
Yeah.
all about you and what you've selected because you know what the story is about to come out on cross almost
Right.
always 98% of the time. So on direct, because you're directing regular people, whether they're CEOs of Fortune 50 companies or whether they are just a shopkeeper, construction worker, banker,
Yeah.
just like we all are. um, so sometimes they've been through this so many times that they might not remember everything. So you have to really listen. You have to
Yeah.
know what you want the story to be, because you know what it is as a lawyer. It's making sure this jury hears the story that you know. And so they may leave out some pivotal important thing, and that you
Yeah.
have to make sure that you ask what that is. And then how to make sure you do not ask the leading question. And when on time trials, I got to tell you, it's such a crutch to be able to go straight back and say, this happened, didn't it? And so, but that's not allowed. You still have
Right.
to have open questions. So
Yep.
making sure that you've gone over the story, this is what's important. Don't worry, if you forget that part, we'll come back to it. It's okay. There was a time we had brilliant inventor. He was up and he was in front of the jury and he had a write board and he was describing what one of their servers looked like and how much bandwidth it had. And so all of a sudden, and I am standing next to the jury box and he's in the front of the jury box. He's a great teacher. But all of a sudden, I mean, he left us, right? I mean, totally left us. So you have to hear with the ear of the jury on direct as well. Like, okay, explain to me what this meant. Explain to us what this means, or explain how you got here. Like, let's back up for a second, pause, so that you're never leaving the jury. Because once you've left the jury, they're making a grocery store list or something, their brains leave. And
Yep.
we would love to think that they are listening to every single syllable of every word that we say, but they don't. And their
They
minds
don't.
wander like other people. Right. And so it's trying to figure out, are you listening to this witness? Is it that important? Why is it important what you're here? So, et cetera. But I definitely think that direct and engaging direct is a craft that is really important. And it's something,
And
you teach young lawyers, because usually they start out with direct. And so practicing that direct in advance is so important.
well, I think it's a very important thing, and often it's underappreciated. I think
Hmm.
it's very important in the trial.
Hmm.
So, how about cross? I think of cross examination, and I agree with you. It's a lot of fun. Cross, your classic cross that everybody's taught is the closed cross, where you're controlling the witness, short questions. You know what they
Yeah.
got to do. But there are people like the most famous example would be Jerry Spence with what I would call the open cross, where he really doesn't care what the answer is. He's just
Mhm.
telling his story, and that's what he's doing with his cross. So, do you ever use different approaches to cross, or do you tend to use one approach more often than the other?
So when I first started out, I did only close cross. That's what we
Yeah.
taught at our firm for young lawyers. And I think that's probably the safest place for them to be. So you know
Oh
where
yeah.
it is.
Yep.
When I started, we didn't have video cross. We do now. But you had your page in line exactly where it was in the deposition. If
Yep.
someone is preparing that for you as a more senior lawyer, you always look to make sure that page in line that's written down is exactly what you think it is, so that you don't have, because if you have the wrong page in line, I mean, the judge doesn't let you look for it or ask somebody else. I mean, this is your opportunity in cross. So you have to make sure it's all perfect on your outline.
But you also have to make sure it's a clear question and a clear answer.
Super clear question, and you don't cut off the answer. So if you
Yep.
ask this really clear question, but he goes on for 5 pages, and what you're trying to get is in the middle of page 2.5, it's just going to be a little more difficult to get there, because you're going to have to read it, and I advise
Yeah.
against that. That helps you be a better questioner on depositions, so that okay, you just gave me this 5-page answer, but all I want to know is, was the light red?
Yeah, you have
When
to
did
learn that skill in depo. So when
Yeah.
they give you the long answer, you say, well, that wasn't the question I asked. I wanted it. Let me ask it this way.
Exactly.
Yep.
Or you didn't ever ask the question, because, sometimes when you're coming at the last minute, things have developed during the case
Yep.
that I see, that wasn't asked about during the deposition, because they were either early enough or they focus on something else, and there's a time limit to depositions, etc. But you have these great exhibits. They better be great, because that's why you're putting them into evidence. If they're not great, don't use them. And so sometimes they have this great sentence in the middle of that exhibit. And so you can put the exhibit up there if your courtroom has like an Elmo, or you can put it on a slide with an interactive
Yep.
tablet, and make sure that the jury's seeing, this is the sentence we're talking about. Now, when you wrote that, so and so and so and so, and so you have that in front of the jury. The more experience you get, you can do open, you can vacillate between multiple documents. You can have more of a killer conversation with the other side.
Yep.
For me, and everybody needs to know their own personality style. It's always easier for me to be who I am, and to make sure that you're always polite, you're always killing this person, but you're really nice. I think that's true for almost anybody, but I can't come in super nice as this lawyer on the direct, and then really tough, on the other side. That really won't work. You just be the same lawyer that you are, but you've got great facts. And remembering, of course, we represent the client. We're the
Yep.
officer of the court representing the client.
Right.
They have not run over our child. It is the facts you're presenting in that particular case. So I think I think that's best for everybody personally. Just keep your civility, keep your integrity, but just make sure this jury knows what's going on here.
Well, I agree with you. I think you have to be professional, you have to be nice, you have to be pleasant.
Mhm.
As a young lawyer in my first few cases, I made the mistake of, I really thought the person I was cross-examining was the enemy and I wanted to try to destroy them. And then I realized, well, I'm being a jerk and the jury's going to think I'm a jerk and they're not
Yeah.
going to like me. So you just be super nice and you ask them questions. And if they don't answer or they're non-responsive, they get mad at the witness. They're not mad at me. So
Yeah.
you're absolutely right, I think.
Yeah, I mean, it's everything. It's just the way your lingo works, within the rules of evidence.
Yeah,
So if you say you just told Mr. Murray this, then you can say that isn't right, is it? You don't really care what the answer to that is because you know it's not right because you have this document that where they've admitted it wasn't right. So
yep.
those are the kind of things that you can, if he says yes, it is right, and then you show this document that he wrote 5 years ago, and he says, yeah, well, no, today it's not right. I don't believe that document anymore. I mean, they just hang themselves all over the place. So
Yeah,
those are always
totally
fun.
him.
Mhm.
Well, how about another thing that I'll bet you might do as an inexperienced lawyer or a young lawyer, we're always taught don't ask a question if you don't know the answer. But
Mhm.
as I tried more cases, I got to the point where I realized I really knew the case and I was going to go cross-examine a witness, and I realized there's a question where I may not know the answer, but they don't have a good answer, whichever way they go. I would ask the question not knowing the answer. You ever do that?
I have, but I tell you, I think it takes a lot of experience to do that. We
Yeah.
were in a big case over trade theft of trade secrets in Dallas, and the client was telling the witness that was about to cross examine the lawyer is about to cross examine the witness. Um, ask this question. He goes, what proof do we have if he gives this great answer? He goes, well, he's lying. It's like, okay, we don't have any proof that he's lying.
Right.
We have
Right.
nothing to back up your side of the story, and you've already testified. So I'm, just trying to make sure. So we did not follow. We still got the same sort of information, but it couldn't be the questions that the client wanted us to ask. And if the client had been maybe more engaged from the get go, or those things had been communicated to the client, it might have come out during discovery, but it didn't, and it couldn't be asked at trial.
But I don't think you want to let the client tell you what to ask because they
Never.
don't, they're not a trial lawyer. But, most trial lawyers will not ask anytime, anywhere, anyhow, a question they don't know the answer. And all I'm suggesting is, on a rare exception, it's
I
actually can work.
I definitely think it can. It probably doesn't need to be on your first cross
Oh,
examination.
no,
Yeah.
no.
But the more experience you have, because you get a feel from where you are. And that
Yeah,
can happen either in cross, or usually you have all this, a big direct outline that you've been through with times, et cetera. I've done it in voir dire where you move from the voir dire outline because all of a sudden you have somebody that's in your field that's
yeah.
important, that this person, once they find out they're an engineer that dealt with this technology, for sure the other side's about to, strike them. And so you want to get as much from that particular witness that they can give you because you know what the invention is and what time frame they did it. So if you get something like that from a regular person that just happened to be on your veneer panel, that's great.
That is great.
Yep.
That is great. Well, I tell you what, this always happens. The conversation goes so fast, and it's just about time for us to wrap up this discussion. It's been wonderful. But Jennifer, you're our national president. And what I
Mhm.
want to ask you now is for younger lawyers who are just starting out, or maybe they've tried a case, but they want to become trial lawyers, they want to learn how to become good jury trial lawyers. What advice would you give them, whether it's something you were given when you were younger or whether it's something you've learned during your journey? What advice would you have to those younger lawyers who want to become good trial lawyers?
A couple of different things. One, be a great communicator. Know your case well so you can talk through issues that you may think will be sticky. I always talk through with good friends on how do we present this. Or if you're in the grocery store line, you got to talk to regular people about your case.
Yeah.
And so, and it not then nothing that's confidential, but just how this plays so you can see where they're coming out outside of your mock trial. So be a really great communicator. volunteer for everything. I
Mm.
mean, one of the ways that I got to try a ton of cases when I was in Dallas and after I moved to Texarkana is because I volunteered to try all kinds of cases, whether it's landlord tenant, whether it's 1983 cases. Just be there, tell the judge, I want to get in the courtroom. This is what I want to tell your partners. I want to get in the courtroom. You can assume all day long that the partner knows that you want to be in the courtroom. There's nothing like telling this partner, I want to be in the courtroom with you on this. Can I have a small role in this case? They may say no on that particular case, but they may let you come and be an integral part. And some of these really larger cases, there may only be three, two, three, maybe four on the outside, is all it really should be per side that are actually taking any type of witnesses or roles. But they take
Right.
a village to try. I mean,
Yeah.
it really does. You may be the mouthpiece, but you're not the creator of every single thing that comes out of your mouth. And so it's really important that you have a great team. And as a younger lawyer, you want to be part of that team. I learned that when I was in Dallas working with Ernie Figueri, that you would have a small case that you did by yourself, whether it's a motorcycle that ran off the road in the city of McKinney and we defended the city of McKinney, or whether it's the Huggies versus Kimball's diaper case, antitrust case, where you're never going to take a witness in that case as a third-year lawyer, but you're going to be able to learn how to really do document discovery. I mean, just so much you can learn as a young lawyer. So you want to have a good mix of both. I also think you be yourself.
Yeah.
I remember talking to Ernie early on in the case, in my career, about he was 6'3" or 6'4". He would walk in the room. He was a Marine. He had this booming voice. And so you knew when if he came into our floor right now, you would know, oh, he's in the house, Ernie's in the house. Whereas I don't have that personality. I mean,
Right.
I can't command a room like that. And so I was telling him one day, I just don't know if this is ever going to work out for me. I was the first woman that they hired. I said, I just don't know if that's ever going to work out. I can't ever command a room like you. And he's like, are you kidding me? You be yourself. In a courtroom, you can do things like this and like this. And he goes, and if I did that, I'm too big. And so I am it's uncomfortable for the jury. Or worst case, I knock somebody over and knock something down. You be
Yeah.
yourself. And so I loved that he gave, because I thought he might say, that's right, you're never going to be any good. So I mean, it's permission to be yourself in the courtroom, and that's who you want to be. And then
Yeah.
I think finally, which I think different firms teach different things, but we've always taught here, and I definitely learned this when I was working at Figueroa and Davenport, always assume the other side is at least as smart as you are, at least as clever as you are,
Right.
or they're smarter and more clever than you are.
Yep.
If you walk in and assume that the other attorney on the other side is not very good, some firms teach that if they don't work here, you're an idiot, that kind of stuff. I mean, seriously, that you miss so much that may be happening
Yep.
because you're not prepared for the other side when they come in and they're really good.
Yep.
Plus, you really want to tell your client that Joe Bob or Sally Jane is not a very good lawyer and you beat him, or, or isn't it better to assume that they're really good and then you won against somebody that's really good? So yeah, you always got to assume. It makes your brain stretch to think, okay, they already know my case like I know it. So what would I do to my client if I were on the opposite side of my
Right.
client? And so you
Right.
could really see it from both sides. If you only know what's on the memo on your side, you're not doing your client a favor and you're really limiting yourself. And I will tell you, the more senior you get, there's more temptations to do that. You got a lot going on. You have a lot of cases that you're trying to digest. And so you get this memo and you don't ask the questions like, okay, so what are the three best points the other side's got against us? Or, what do we flub up? Or what are the bad documents against this witness? And sometimes we're moving too fast. That I've seen that not happen. And you definitely want to be prepared for that.
Yeah. Great advice, all of it. I think the thing you got from your firm is so true. You always want to assume your opponent's as smart or smarter, as well prepared or as prepared. I've always thought I may not be the smartest one in the room, but nobody's going to out prepare me.
That's
I want to
right.
be ready. I want to be ready to go. And then great advice. Well, Jennifer, thank you so much for taking the time
Thank
in
you,
your
Monty.
busy year and for sharing this great information. It's been a real pleasure. And thank you for all the good hard work you're doing as our national president this year. And keep up that good work.
Thank you, Monty. We're going to need it this year. So thank you very much.
All right.